Unmute and let me know who you are.
Emmanuel Simmons.
Hi, Mr. Simmons. Let me change your screen name. And Mr. Daly is your attorney, so
Yes.
he should be here shortly. Change this. And Mr. Daly in there. All right, I've changed your screen name. He shouldn't be too long. He's usually one of the first ones here and in front of Judge Olsaber, so it'll just be a few minutes, all right?
Okay, thank you.
Thank you. All right, so Mr. Byers, you want to come on up? All right, this is in the matter of the people of the state of Michigan versus me Byers, file number 23-21531FH. This is a date time set. Let's see here. All right. Mr. Byers, this is a date and time set for probation violation. And we have a sentencing recommendation. I think we've adjourned this a couple times and you've been making payments. So I think the most recent one I have is a note from February 5 stating that you have paid 810 of the ordered 2,000.
I paid 400 of it today too.
Today?
Yeah.
So you paid another 400?
Yes, ma'am.
Okay. Let's see here.
I have a question.
Hold on one second. I'm looking up something. So give me just a second. All right, so I don't know if they did it already, but I'm going to wipe the attorney fees that are like $450. So I'm not sure if they already did that or not. They may.
Mr. Murphy had mentioned something about that. Yeah.
Did they already wipe it?
I'm not sure. He did mention it to me and said that he was gonna.
Okay, so I'll get rid of the $450 and a court-appointed attorney fees. You paid another $400 today. Okay, we have till May, so I'll adjourn this out a month and see if we make another payment. Okay, so
Do I
actually,
have an attorney?
do you? Is it Miss Underwood?
She called me last night and said that she was my attorney, but I wasn't aware that I had an attorney.
Probably asked for court-appointed counsel.
No, I did not.
Okay, so you don't have an attorney,
I
but
didn't think I needed court.
as long as you're making your payments, it's up to you.
Okay.
Do you want an attorney?
No, I don't need.
All right, so I'm gonna set this out to March 21. Ms. Adams, can I get a notice from Mr. Byers? And we'll double check that the 450's been forgiven. And if it hasn't, we'll get that taken off and then keep continuing to make payments, okay?
Okay.
So March 31 at 8 a.m. All right, so sir, go have a seat back there and I'll have you come up, okay? Go sit. Okay. So ma'am, can you, I know your name, but for the record, I need you to put your name on the record.
Becky Preisner.
All right.
The last time we were here, Judge, December 18th, you asked him if he thought he could pay this all off by the end of January. And he was like, no, I have Christmas. And you were like, okay, well, then we'll set the date today to see if you made any payments. He told you on that day that he had made a payment on December 17th. He never did. He never paid. He hasn't paid until today, and that's because.
So that's not true because the probation department told me he did pay $800 since the last time we were here.
No, I just talked to his probation officer.
I got a
He
note
told me
from
that
his probation officer that
He
said-
told me that
so-
he wrote something that told you he wanted you to make him pay the remaining balance today.
That's not what I have.
That's what his probation.
I
officer
understand
told me.
that,
I
but
have-
this,
I have
ma'am,
it
I'm
today.
not gonna talk over you. I understand your frustration because you want your money.
It's not just that.
Listen to me, stop talking. The note I have is said he paid $800. I expect he will be bringing a payment. This case expires in May and he still owes this amount. So he has until May to pay this off. But let me tell you what would happen. If I put him in jail and revoke and terminate, right, which would happen, then you'll have to file a civil lawsuit to get the money from him. And then you're gonna have to spend money and time. So this way, jail is hanging over his head and he's making payments.
My issue is that we have been coming here, we're going on 2 years now.
Mhm.
It's ridiculous. He keeps telling everybody, I want this to be done and over with. I want this to be done and over with, blah, 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 blah. Well, then just pay the money. Just pay me my money and we don't have to keep coming into court. We don't have to keep seeing each other because I don't want to keep coming here. I don't feel like it makes a difference if I'm here with you or not, honestly, but his probation officer tells me that I should be here because I am the victim.
Yep, and you have a right to be here.
So I just want justice, Judge.
You're getting it, you're getting your restitution. Like, I'm gonna, how much do you make an hour?
I don't need to tell you that. I work
Okay,
about
but
this
what I'm
children.
saying is
I make good-
$3,000, I'm not
I make
talking over
good
you,
money.
ma'am. It's a lot of money for most people who make minimum wage. And hopefully he gets his income taxes back and he's smart enough to pay this off.
Well, we'll see, because we're here because he's not smart enough.
So, all right, thank you. All right, you've got a notice of hearing. We'll see you back on that day. You guys just have a seat. Don't leave for a few minutes, please. All right. Miss Underwood, I'll call the jail for Mr. Collins. Do you have Mr. Collins? No.
Yeah.
Does Mr. You do? Okay.
What are we gonna do?
Hi, this is Judge Ian Salone. I am ready for Mr. Collins.
Okay,
All right, thank you.
thank you, bye-bye.
Bye-bye.
Your Honor, the only other one I have,
Is
at this
Hernandez
time.
Ramirez.
right, but I suspect the AG is in the other courtroom waiting for me in there on a case.
What? Yeah, and it's not 8:30 yet, so
Hmm,
yeah. And it's not till 8:30, so whatever is fine.
Your Honor, I don't believe Mr. Collins has entered a plea on this yet, has he?
Right?
Mr. Collins and I were talking about this yesterday. I don't believe he's entered a guilty plea
Okay.
on this, has he?
I don't know. Nope, so far it's a not guilty plea.
Okay. He thought he
You can go
had,
now.
but we're going to be entering a plea.
Okay. Right, we are just, oh, I got Mr. No. I don't. All right, I'll just be a minute. Right. Don't worry.
He's on Zoom. I can check. Yeah. 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 Did you?
Yeah. I'm sorry. Attorneys aren't allowed to go to this area.
I was checking in.
She gotta take her down next time.
I was checking in.
She don't check in. This is Lenawee County,
I was checking everywhere else.
not in circuit court. I can see you. Why do you gotta check in?
You didn't check on me.
I just checked in over there. Different rules.
Different rules, different courts. You know, in Hillsdale, I would try to stand and they would be like, sit down. And I'll be like, okay. All right. All right, Mr. Collins?
Yes, ma'am.
Okay, this is in the matter of the people of the state of Michigan versus Darius Dwayne Collins. File number 24-21767 FH, 24-21798 FH. Miss Underwood. Hold on. Okay, I don't have Miss Underwood. So Mr. Simmons, why don't you go ahead and start your video and I'll, oh, well, now I have Miss
I'm
Underwood.
sorry, I'm
Okay.
here.
It's okay. So Miss Underwood represents Mr. Collins. This is the date and time set for a probation violation. Hearing Miss Underwood, how would you like to proceed with Mr. Collins?
Mr. Collins would like to enter a plea guilty on that, Your Honor, and have his sentencing set down for the same day as his sentencing on the new charges, which is the 28th, I believe.
February 28th?
Yeah.
All right. All right. Is that right, Miss Adams?
I am so sorry, Judge. I missed what you said.
Hang
We have
on.
Mr. Collins down for sentencing on February 28th for a new felony.
28.
Yes, ma'am.
Yes, on file 22082.
Okay, great. All right, so Mr. Collins, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, so Mr. Collins, you've heard the statement of your attorney. Is it your intention today to plead guilty on the 2 violation of probation warrants?
Yeah.
All right, so on file number, both files allege the same things, that you violated your terms of probation by pleading guilty to a controlled substance possession of methamphetamine on January 15th in this court, and that you were ordered not to use any controlled substances. And then you did test positive for cocaine and methamphetamine on January 8th. So that's the allegation on both files. On file number 24-21767 FH, the maximum penalty you could be facing if you plead guilty or found guilty could be up to 4 years in prison. And then on file number 24-217998, you're currently on probation for attempted larceny in a building, which carries a maximum penalty of up to 2 years in prison. Do you understand that?
Yes, ma'am.
Okay, Mr. Moore, this is a Sarah Teskey file, by the way, Mr. Moore.
Okay.
Okay. All right. So, Mr. Moore, You've had, or I'm sorry, Mr. Moore, Mr. Collins, you've had ample opportunity to speak with your attorney.
Yes, ma'am.
Are you satisfied with Ms. Underwood as your attorney and the advice that she has given you?
Yes.
All right, do you understand? I think I gotta swear you in. Raise your right hand.
did.
Already did? Okay. So do you understand you have a right to contest these violation of probation charges and to have a trial on them? Do you understand that?
Yeah.
So Mr. Simmons, I'm gonna pop you in the waiting room a minute because I kind of get vertigo when people are walking around and I'm watching the screen. So I'm gonna put you in the waiting room and you'll be next because Ms. Dumont is here for you, all right? Okay, so Mr. Collins, do you understand that throughout the trial, you would be presumed innocent until your guilt is proven by a preponderance of the evidence? Do you understand that?
Yes, ma'am.
You have a right to have all the witnesses against you appear at your trial, to have your lawyer ask those witnesses questions, or you may ask them yourself, and to have me order any witnesses you might have to appear at that trial. Do you understand that, all of that?
Yes, ma'am.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold it against you in any way. Do you understand all of that?
Yes, ma'am.
On the other hand, do you understand that you have a right to testify at your trial if you want to testify?
Yes, ma'am.
How do you plead to the charge that you violated the terms of your probation by pleading guilty to possession of methamphetamine on January 15th of 25, and then using and testing positive for cocaine and methamphetamine on January 8th of 25? Guilty or not guilty?
January 15th, 2025, I was currently incarcerated, so how would that make
Oh,
any
maybe I
sense?
misread it. No, I put you in jail on the 8th because you tested positive for methamphetamine, right?
Yeah, so how would I be
then-
charged for something?
And then you pled guilty to the new possession charge on January 15th, did you not?
Yeah, yeah.
Okay, so I might have reversed those dates. I'm sorry. So is
Okay.
that correct?
Yes.
Okay, and do you understand by pleading guilty, you'll be giving up a right to a trial, as I've already explained to you?
Yes.
Has anyone promised you anything to get you to plead guilty?
No.
Has anyone threatened you in any way to get you to plead guilty?
No.
If I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes.
Is it your own choice to plead guilty?
Yes.
All right, so Mr. Collins, on January 8th of 2025, we had a drug test done on you at the courthouse. Is that correct?
Yes, ma'am.
And at that time, you tested positive for cocaine and methamphetamine. Is that correct?
Yes, ma'am.
All right, and that was a violation of your terms of probation. Is that correct?
Yes, ma'am.
All right, and then we were here on a pretrial on January 15th of 2025, and on that day, you pled guilty to controlled substance possession of methamphetamine. Is that correct?
Yes, ma'am.
All right, and so that would be a violation of probation because you committed a new offense. Is that correct?
Yes, ma'am.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. I'm going to refer this matter to the probation department for an updated probation violation report. And I'm just going to set it in a couple weeks over to February 28th at 8:15 in the morning with his other sentencing. And someone will be over to speak with you and they'll do the probation violation report. All right, Mr. Collins?
Okay.
All right. All right. Thank you. Well, do you want to appear in person or via Zoom? I don't remember what you asked for the other one.
Person.
Okay. I'll put you down in person. Okay.
Okay.
All right. Thank you, Mr. Collins.
Thank you.
Just so you know, Joanne, Mr. Malaro will be appearing on behalf of John Glazier on Good Friend.
Okay, thank you, Judge.
Mhm. All right, so let me let Mr. Simmons back in. Miss Underwood is gone. All right. Mr. Burke, I believe Miss Underwood just went down to Judge Olsavers to take care of the case down there, okay?
And I'm on that case I'm on that case with her and Judge Olsavers, Your Honor. So thank you. I just wanted to check with you.
Okay, I'll see you guys back in a few.
Thank you.
All right, let's see, hold on, Mr. Simmons, 1 second. Good friend and Brown.
Good morning, Judge Angelo, Deputy Miller.
Good morning. So I am also ready on Good Friend and Brown.
Good friend, and which one?
Brown, yeah, Joseph Brown.
Okay, sounds good. I'll get up there for you.
All right, thank you.
Yep, bye-bye.
All right, so Mr. Collins is done, so let me put his file away. Okay, so this is in the matter of the people of the state of Michigan versus Emmanuel Simmons. We have 3 files, 24-21830 FH, 24-22051 FH, and 24-22052 FH. I have, Mr. Berkey, were you going down to Judge Olsavers' court? Mark Burke, are you going down to Judge Olsavers with Rhonda?
Your Honor, sorry about that. I am, but I'm on my mobile phone with Judge Olsavers, so I can stay on my computer with you, Your Honor. That's fine.
Super clever. Okay, thank you. All right.
Thank
I
you.
have Isaac Sneed appearing on behalf of the people, and I have Katerina Dumont appearing on behalf of Mr. Simmons. I do have a February 4 of 2025 letter from my pretrial services coordinator, Darren Coast, who states that Mr. Simmons has done an excellent job with his drug testing. He does not miss and has a medical marijuana card, so test positive for marijuana. He does suggest we continue testing at this time. So, Ms. Dumont, how do you wish to proceed today on behalf of Mr. Simmons?
Judge, I believe a trial date is set for February 27th at 9 a.m. I believe Mr. Daly advised me that they still want to proceed to trial. I do know that there was an issue brought up between Mr. Daly and Mr. Simmons with regards to maybe a motion to quash. I know that we have to look into that, and that was the first
motion deadline is today.
Yes.
So, all right. So we are set for trial on February 27th of 25 at 9 a.m. And that was filed and heard by. So I know the plea agreement was to plead to count 2 with the Cobb's agreement to 1 year jail deferred. So there would be probation, no jail time up front. Obviously, if he gets convicted at trial, he is a habitual offender 4th offense, and he is facing a life offense. So if he's convicted at trial, he will be looking at life in prison, and the agreement gives him a deferred jail term and probation. So we will see you back for trial. Thank you, Mr. Simmons. You're all set.
Thank you.
Mr. Daly doesn't have anything else today, right?
No, Judge.
All right, let me see. So I got Mr. Malaro. So, that's Michael Dagger, Margosian. Bye, have a good day. Mr. Malaro, I have Charity Smith in my waiting room.
Okay. All right, Judge.
Charity Smith, why don't you start your video? All right, this is in the matter of the people of the state of Michigan versus Charity Christina Smith, file number 24-22056FH. This is a date and time scheduled for pretrial in this matter. I have Salvatore Malaro appearing on behalf of Ms. Smith, and I have Isaac Sneed appearing on behalf of the people. Mr. Malaro, looks like this is a third pretrial. So Mr. Malaro, how would you like to proceed?
Judge, I would like to adjourn this for one more pretrial. We're still working towards resolution.
All right, so, March 5 at 8:30 in the morning.
Judge, the first 2 weeks of March are not a good time for me.
March 19 at 8:30 in the morning.
That'd be fine.
All right, if there's no resolution by that time, I will be setting it for trial. So Ms. Smith, your next court date is March 19 at 8:30 in the morning. Mr. Malaro, you do the stip in order to adjourn.
Yes, Your Honor.
All right, and we will see you back on that day. Thank you, ma'am.
Thank you.
Judge.
Thank you. All right, let's see. I have someone joining me from the jail. Can I ask your name, please?
Joseph Brown.
All right, Mr. Brown, let me find you. Okay,
Hey, it's Miller. You guys called?
so this is in the matter of the people of the state of Michigan versus, let me get there, Joseph Brian Brown, file number 24-22087FH. I have Salvatore Malaro appearing. Is something wrong with Mr. Brown's Zoom?
No, you called and I missed your call. Just wanted to.
Oh, yeah, I just was gonna let you know that I'm ready now too for Antoine Carter. That's all.
Okay, sounds good.
Thank you. All right, so Mr. Brown is represented by Salvatore Malaro, and I have Isaac Sneed appearing on behalf of the people. Mr. Malaro, how would you like to proceed today on behalf of Mr. Brown? I'm sorry, we have no audio. I apologize.
About now. Can you hear me now?
Do now.
Your Honor, I'd ask to adjourn this for an additional pretrial. I need to sit down with Mr. Brown and the prosecutor and see if there can be a resolution in this matter.
Would that March 19th date work?
Yes, it would, Your Honor.
So Mr. Brown, I'm gonna set this over for a pretrial on March 19 at 8:30 in the morning. And Mr. Malaro, you do the stip in order to adjourn. Mr. Steen, can you sign your name with permission?
Yes, thank you.
All right, Mr. Brown, I'll see you back on that day. Thank you.
Thank you.
All right, and new must be Mr. Goodfriend.
Yes, ma'am.
Okay, so this is in the matter of the people of the state of Michigan versus Brian Lee Goodfriend, file number 24-22091FC. So this is a Mr. Glazier file, but you're covering it today, Mr. Malaro? No audio, I'm so sorry.
How about now?
Yes, sir.
Okay, Your Honor, the note Mr. Glazer has is the adjourn this for a second pretrial. So that would be my request.
Mr. McCready, you're actually on this file?
Yes, that's correct.
Okay, I have Dave McCready on this file. All right, so did Mr. Glazier say how far out?
He did not.
Okay, how about March 12th?
Judge, it does say in the notes there's been a transcript ordered. So, and the exam was held on the 26th of December. So it probably should
When
go
was-
out of the way. December 26th was the exam. It says.
That's
Do you know
correct.
when that request for a transcript went out?
January 18th. Or maybe the
So we
10th, I think. Could have been 10th, John's notes are, his handwriting's atrocious.
Okay, I will set this out to April 23rd at 8:30 in the morning. Obviously, if that comes in sooner and there's a resolution or you want a sooner pretrial, just let Miss Adams know and we will set this sooner. But I do allow for 90 days for transcripts. So, Mr. Goodfriend, we will see you back on, I think I said April 23rd at 8:30.
Okay. Has there been anything done with my bond?
I don't know.
I met
what do
with
you?
Mr. Coast, after court. And it was.
Yeah, I have a note. Hold on. So I did have, you have a note dated January 2nd. It says a pretrial assessment was done for Mr. Goodfriend on January 2nd. He's been in jail since November 4 on a $200,000 bond for 2 counts of first degree CSC, which is a life offense. If he's released, he needs to be able to wear a GPS tether and afford it. He is in the moderate risk range of being arrested while out on bond and not appearing for court. He is not employed. He does not have a stable residence. He's been couch surfing. He did complete inpatient. He did not successfully complete their program. So based on that, I don't see that anything that would indicate to me that release. But Mr. McCready, would you like to weigh in on that?
Yes, sir, just for the court information.
I can't hear you, Mr. McCready. I'm sorry.
You can't hear me?
I can now.
Oh, okay. Mr. Goodfriend had indicated before being charged that he knew that the victim had gone to the police and that he was probably going to flee to Texas or someplace, but I believe it was Texas. Once the charges were authorized, he turned off his phone for days, if not weeks, and tried to avoid apprehension by the police. So I agree with the court that at this point, it would be inappropriate to change his bond.
Mr. Malaro.
Your Honor, since I'm not familiar with the circumstances of this case, I did put a note in the file for Mr. Glazer to file a written motion to modify bond if he thought it was appropriate. So,
Mr. Goodfriend, based on the pretrial assessment, I am not going to change your bond based on an oral motion, but your attorney can file a written motion, all right?
Okay, thank you.
Thank you, Mr. Goodfriend.
Thank you.
All right, so, I have another gentleman at the jail, and hold on, I'm gonna guess your name is Antoine Carter.
Hi, Ms. Angela. Hi, Judge.
Hi, Mr. Goodfriend, you're all set. You can go.
Thank you, ma'am.
Thank you. All right, so in the matter of the people of the state of Michigan versus Antoine Carter, file number 24-22086FH. I have Matthew Murphy appearing on behalf of Mr. Carter. Oh, and I'm sorry, and Mr. Sneed appearing on behalf of the people. This is the date and time scheduled for a first pretrial conference in this matter. Mr. Murphy, how would you like to proceed?
Your Honor, could I have a brief breakout with Mr. Carter, please? I spoke with him yesterday, but I need to speak with him again further and then proceed on the record.
Yep. All right, so Mr. Carter, I'm going to open up a breakout room and give you an opportunity to speak with your attorney, okay?
Okay, thank you.
You're welcome. And you're in jail Zoom 6. All right. Go ahead and join that breakout room. Got Rhonda Underwood back. All right, so does anybody have a case here today or just watching?
I have a case.
What's your name? All right. Mr. Malauer is your attorney, so why don't you come up to the podium, okay? And stand in front of that microphone.
I have a question. I don't know if I missed it or if I'm in the wrong room and it's that room, but there was a Kevin Mender, or if it was already done.
It's not mine.
Oh.
I don't recognize that name.
I'm sorry, I didn't catch her name, Judge.
She's general. Oh, this is in the matter, Malika Rembert.
Thank you, Judge.
All right, this is in the matter of the people of the state of Michigan versus Malika Nataya Rembert, file number 24-21966FH. I have Salvatore Milaro appearing on behalf of Ms. Rembert, and I have Isaac Sneed appearing on behalf of the people. So, all right, so Ms. Rembert, you were released to Harbor Light, right?
Yeah.
Did you complete that? Say it again. You gotta speak
Yes.
louder for me.
Yes, I did.
Okay, very good. All right, Mr. Milaro, this is the date and time set for a pretrial conference. And it's the February 5. So this is a second pretrial. So Mr. Milaro, how would you like to proceed today? I have no
Judge?
audio. Yeah, yep, now I have audio.
Okay, so Judge, we were resolved a matter she had in district court yesterday. And what I'd like to do is adjourn this matter so I can talk to the prosecutor and see if this matter can be resolved. So I'm asking for one more additional pretrial.
All right. Who's your prosecutor on this one?
Not sure.
It's me, Your Honor.
It's Isaac Sneed.
All right. So my next available is March 19 at 8:30 a.m. Miss Adams, could we do the notice of hearing so we can serve Miss Rembert today with her paperwork? So you don't need to do a step in order, Mr. Milaro. So Miss Rembert, stand right behind you, and then we'll get you a notice of hearing for March 19th. All right?
Okay.
Yep, right on that bench. Yep. Thank you.
Thank you, Judge.
All right. You're welcome. Let's see. Tomorrow, I don't know if I have.
Judge, it says that's all I have with you. As soon as Miss Rembert's done,
Yes,
I'll
so you're all set.
leave
Thank you.
with your permission.
All right, thank you. All right, so Miss Underwood, you and oh, he's not here. All right, so in the matter of the people of the state of Michigan versus Oscar Hernandez Ramirez, file number 24-21965FH. One of these. I have Rhonda Underwood appearing. Is it Burke? It's Burke, right? Not Berkey or Burke?
It's Burke, but I get Berkey every day, so I answer to both, Your Honor.
Well, I get called all kinds of names that I don't want to be called. So I don't know why. Sometimes I remember, I don't. All right. So I have Mr. Burke appearing on behalf of the Attorney General's office. Miss Underwood, Mr. Hernandez Ramirez is not present today, which
Your Honor, I'm not sure where he would be. I know he pays really well.
yeah, and he's always here, so I'm really not sure why he wouldn't be here. Like, he shows up and he's been paying. Mr. Burke, have there been payments?
Your Honor, I can enlighten the court. There has been regular payments have been being generated since then. In the amount of, it started off at about $736 every 2 weeks. There was one payment in late January that was only $675. That was on January 24th of 2025. I think that's the last payment that I show reported, but that makes sense because that was only about a week and a half ago, maybe 2 weeks ago. He is making payments. I'm encouraged by that. His arrears is just north of $16,000. He has an ongoing support obligation of over $1,000 a month, so it's kind of a high obligation. But he is making payments more than that every month. So he is chipping away at the arrears. So naturally, I don't like the fact that he's not here, but I mean,
I don't want people to miss work when they're paying. So
yeah, but I mean, Yeah, I mean, true, but it's
I-
also by Zoom. It's, you know, it's 8:30 in the morning. It's not like it's in the middle of the day. But
Right.
we put all that aside. You know, if the court wants, I mean, Mr. Underwood and I talked about adjourning for some time to have him continue to make his payments. I have no problem with that. I mean, assuming he's, you know, assuming he's still working and the income is still with, you know, being withdrawn. So,
So he has, and I keep track of it, he has historically always appeared, so, you know,
Yeah.
I don't know if you didn't get a notice for today, I have no idea, I didn't send the notice out on this, so, do we want to set this out like 2 months, 3 months?
Yeah, that would be my preference, Your Honor.
Your Honor, I would normally say 3 months, but because the defendant's not here, maybe we do it 2 months just to make sure
2
that
months. That's
to make sure
fine.
he's still,
And I would
he's
be
still
happy
around,
to
he's still
do the
working.
stipend with Mr. Burke's permission.
All right, I'm gonna mail it out, we'll have a notice mailed from the court to him, so I'm gonna
That's
set this
fine.
out to
That's
April
even better.
30th. Okay, April 30 at 8:30 in the morning. And Miss Adams, can we please mail the notice on this?
Yes, Judge.
So that takes care of that. Mr. Burke, you have a great day. Thank you.
Your Honor, thank you very much. You too. Nice to see you.
All
Thank you,
right.
Ms. Underwood. Always a pleasure.
You too, Mark. Bye-bye.
Thank you. Thank you. Talk soon.
Okay, so Miss Underwood, hold on one second.
I
Okay,
think
that's all I
it
have with you
until
till
our bench
10:30.
conferences.
Hi, what?
I said, I think that's it until our bench conferences.
Yep, 10:30, so thank you. All right, Mr. Murphy, we are back with Mr. Carter. So, Miss Rembert, you're all set if you're ready to go, or you can stay and watch. Okay, good. All right, so we are back on the record with Mr. Carter. So, Mr. Murphy, how do you want to proceed today?
Your Honor, thank you for allowing me to have that breakout session with Mr. Carter. We're going to ask to adjourn for another pretrial on this matter. I was asking the court if we could do maybe March 19th or later.
Okay, so we'll set this out to March 19 at 8:30 in the morning. And Mr. Murphy, you can do the stip in order to adjourn. Make sure you send a copy to him at the jail, all right?
Yes, Your Honor. I'm sorry. Could I was trying to find, he does have a bond on this file, correct? He's not on a PR bond. He does have a cash bond. Or
I don't know, unless he's being held on something else.
well, I mean, he is in jail on a sentence, so I just wanted to make sure he's going to be getting credit for the time he's served on this file as well.
Well, one, I would always give him credit because
If I could interject here, Judge, my notes say that bond hearing was set at $1,000. That may be the district court bond amount.
All right,
yeah, he's
there's
got
been no change
$1,000
since-
cash surety from December 23rd. Yep,
All right, thank you. Thank you.
he's getting credit. All right, Mr. Carter, we will see you back on that day, okay?
Okay, Judge Angelone, appreciate your time. Thanks. Thank you, man.
Yep, thank you,
Thank
Mr.
you.
Carter. I'll talk to you soon, okay?
All righty, y'all have a good one.
Me too. All right, so I think we are done with the jail today. Hold on. Yep, we saw Goodfriend, we saw Brown, Carter, and Collins. So I'm gonna get rid of these jail windows. Okay, so in the matter of, the matter of the people of the state of Michigan versus Christopher Joseph Kassar, file number 2020-201 or 3FH. This is a date time scheduled for show cause in this matter. Mr. Kassar was mailed a request and summons for probation violation. He has absconded basically at this point. So I'm going to issue a bench warrant for his arrest for failure to appear. He's not here via Zoom, not in the hallway, and he's not in the courtroom. I will set bond in the amount of, charge. 25,000 cash. All right. In the matter of the people of the state of Michigan versus James Vernon Renner. Multiple files, file number 21-20539FH, 22-21119FH, and 22-211 20FH. This is the date and time scheduled for request and summons for probation violation, which also alleges that he has tested positive for illegal controlled substances and absconded. I will issue a bench warrant for his arrest for failure to appear on each file. And I will set bond in the amount of 25,000 cash on each file. All right, so that takes care of Mr. Runner. And Mr. Murphy, in the matter of the people of the state of Michigan versus Blake Anthony William Barton, file number 23-21272FH. Mr. Murphy, is Mr. Barton present with you?
He's not, Your Honor. I could try to call him if you give me a few minutes. I didn't realize he wasn't in a Zoom.
All right. Mr. Dagger Margosian, in the matter of the people of the state of Michigan versus Manuel Bowman III, file number 24-22085FH. Okay, this file. Of Isaac Sneed appearing on behalf of the people, Michael Dagger Margosian appearing on behalf of Mr. Bowman, and this is the date and time scheduled for a first pretrial conference in this matter. So, Mr. Dagger Margosian, how would you like to proceed today?
Your Honor, good morning. This is a pretrial. We have reached a resolution with the people. Mr. Bowman would be entering a plea to attempted felonious assault. There would be a sentence agreement for no upfront jail and an agreement for no further charges in this investigation. And at that time, we would be ready to enter a plea at this time.
Is that a correct recitation of the plea, Mr. Sneed?
Yes, it is, Your Honor. I don't have any paperwork ready. I didn't realize he was intending to plead today. So maybe if we could have one more week, I can prepare that.
Okay. If that's the plea offer, I can take the plea today unless, and you can amend the information today if you want, because next week I've got like 20 next week.
Okay, yeah, we can proceed today, Your Honor.
All right, so, okay, so the plea offer is to add a count 3, attempted felonious assault, which carries a maximum penalty of up to 2 years in prison, no upfront jail, no further charges stemming from this time period, Mr. Dagger Margosian, of February 13 through April 3rd of 24.
Correct. Yeah, I guess I would call it this investigation, but yeah, that during that time period.
Okay, and then count 1, count 2 would be dismissed, as well as the habitual offender 4th offense notice. And there was a Killebrew agreement to no upfront jail. So, Mr. Sneed, does that accurately reflect the plea?
Yes, thank you.
Okay, and then thank you for working with us on that, Mr. Sneed. All right, so Mr. Bowman, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, and I'm going to need you to speak up louder for me, and you can put your hand down.
Okay.
All right, can you state your full name for the record?
Manuel Bowman III.
All right, Mr. Bowman, thank you. Now, Mr. Bowman, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention today to plead guilty to an added count 3 attempted felonious assault with an agreement that between the prosecutor and your attorney that there would be no upfront jail and no further charges? So is it your intention to plead guilty to that count?
Yes.
Are you satisfied with Mr. Dagger Margosian as your attorney and the advice that he has given you?
Yes.
You understand, while there's an agreement for no upfront jail, if you were to violate probation, I could send you up to 2 years in prison. Do you understand that?
Yes, ma'am.
All right. Other than the agreement that was placed on the record, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court other than what was placed on the record. Is that correct, Mr. Sneed?
Yes, Your Honor.
Is that correct, Mr. Dagger Margosian?
Correct, Your Honor. Thank you.
And Mr. Bowman, is that correct as far as you're aware?
Yes.
All right, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial, have witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand, Mr. Bowman, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes.
Okay. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you understand that?
Yes.
All right. And there'll be no requirement for sex offender registration at all under this plea, correct? Mr. Dagger Margosian and Mr. Sneed?
Correct, Your Honor.
Correct.
Right. So, Mr. Bowman, do you have any questions about the rights that I've given to you?
No.
All right. So, Mr. Bowman, how do you wish to plead to the charge that during the time period of February 13 of 2024 through April 3rd of 2024 in the city of Adrian in the county of Lenawee, that you did commit the offense of attempted felonious assault? Guilty or not guilty?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Sneed?
No, Your Honor.
Mr. Dagger Margosian?
No, Your Honor.
All right, Mr. Bowman, I know there's an agreement for no upfront jail, but in terms of fines, costs, or probation, has your attorney promised you any particular sentence or estimated what your sentence will be?
No.
Okay, so he told you you'd probably get probation and fines and costs, but he didn't tell you like how long or how much, right?
I thought he said 2 years.
It could be, yeah.
If Judge, can I clarify?
Yeah.
Manuel, like we talked about, that's the maximum penalty on this offense, but we don't because there's not going to be any upfront term of probation. But if you violate on probation, you could be subject to incarceration, but you will be on probation. So that's what we've talked about before.
Okay.
All right. So, okay. So, Mr. Dagger Margosian, first I'd inquire, am I going to take the plea to the factual basis of count 1 or count 2, or do you wish to voir dire for purposes of this plea?
I'd like to voir dire if that's okay.
Fine, go ahead.
Mr. Bowman, between the dates of February 13th of 2024 through April 3rd of 2024, was there physical contact with an individual with the initials of SR?
Huh?
Judge,
So,
can I have a-
Mr. Bowman, hold on, Mr. Bowman, I need you to look at us. I don't know who you're looking at, who you're talking to, but stop. Mr. Bowman, and whoever you are, get off the screen. So, Mr. Bowman, we do not use full names of victims in these type of offenses on the record. So Mr. Dagger Margosian is using the initials of the individual who was the victim in this offense. Do you understand that?
Yes.
Okay, and so when he says those letters, that is the initials of the victim, okay?
Okay.
All right, go ahead, Mr. Dagger Margosian.
Thank you, Honor. Mr. Bowman, between February 13th, 2024 and April 3rd, 2024, did you have physical contact with somebody with the initials SR?
Yes.
Okay. And was that in the city of Adrian, county of Lenawee, state of Michigan?
Yes.
Okay. And would you agree that that physical contact was unconsented to?
Yes.
Do you agree with that? I'm sorry.
Yeah.
Did the court pick that answer up?
All right, I did.
Okay.
He said yes. Is that correct, Mr. Bowman?
Yes.
And Mr. Bowman, during this unconsented to physical contact, would you agree that there was a weapon or a perception of a weapon?
Huh?
All right, Judge, can I have a breakout room?
Okay, so Mr. Bowman, would circumstances of that event led that individual who was the victim in this case to believe you had a weapon?
No.
Okay, I'm gonna put you in a breakout room with your attorney and let you guys
Okay.
have a chat. And hold on. So I'm gonna send you an invitation to join a breakout room, Mr. Bowman. You're gonna join that breakout room. When you're done, I'll bring you back. So if you don't know how to come back in, don't worry, I will bring you back. All right, go ahead. Join that breakout room. Mr. Murphy, I have Blake Barton. All right, Mr. Barton, how are you? Mr. Barton, can you hear me?
Whoa.
He needs to pick his phone up there. He's walking around trying to get reception.
Your Honor, we were just going to continue to the bench trial schedule for the 14th. So,
No. Mr. Barton, can you hear me? Okay, okay. So this is in the matter of the people. Why do I write this file? In the matter of the people of the state of Michigan versus Blake Anthony William Barton, file number 23-21272FH. I have Isaac Sneed appearing on behalf of the people, and I have Matthew Murphy appearing on behalf of Mr. Barton, who is logged in. We do have audio of him. It appears he's having difficulty getting audio of us. And so This matter is set for a bench trial on February 14th at 10 a.m. He is charged with operating while intoxicated, third offense, and operating with license suspended. This is a habitual offender, second offense. So the maximum penalty would go from 5 years to 7.5, actually. So we will see you back for that continued bench trial. If anything changes, let us know. And call Mr. Barton and text him or something and let him know we're all set.
Yes, Your Honor. Thank you.
All right, Mr. Barton, you're all set.
Thank you.
Thank you.
We heard that.
We heard that.
Thank
Yep.
you, Your Honor. That's all that I have scheduled. You have a good day.
All right, you too. Thanks. All right, so Mr. Sneed, is that your case, Mr. Sneed?
No, it's Alex's.
Mr. Sneed, I'm gonna send you. Hold on. I'm typing. There you go, Mr. Sneed. All right, let me bring Mr. Bowman back. All right, where'd he go? There he is. Okay. So we are back. I think he's kind of got a fuzzy. All right, Mr. Bowman, can you hear me?
Yes, I can, Judge.
All right, so we are back on the record, and you were asking at this point, you were inquiring about alleged use or imagined use of a weapon. So Mr. Decker-Margosian, you may proceed.
Okay, Mr. Bowman, so back to establishing the factual basis here. You did have unconsented to contact with the individual with the initials SR, correct?
Yes.
All right, and during that time frame, there was either use of a weapon or a perceived use of a weapon from her, correct?
Yes.
Okay, and would you agree that the weapon would be your hands?
Yes.
Okay, and again, this was unconsented to.
Yes.
Okay, I think for attempted FA, I'm satisfied, Your Honor.
Mr. Steen, are the people satisfied?
Your Honor, I don't know that hands can qualify as a dangerous weapon under the statute. So I'm not satisfied.
So the underlying offense is a criminal sexual conduct. So Mr. Decker-Margosian, perhaps if you clarify that a little bit for purpose of the plea. So so Mr. Bowman, would you agree that did you have sexual contact with the individual listed in that Mr. Decker-Margosian was referencing?
Say that again. I didn't understand.
Try again, Mr. Decker-Margosian, go through it again. Mr. Snee, would it help if we plead more to try to put in the elements of count 1 or count 2 for purposes of the plea?
I believe so, Your Honor.
All right, so Mr. Decker-Margosian, want to finesse that a little bit for us?
I think it would have to be a no contest at that point.
Okay. Mr. Snee?
I have no objection to a no contest plea.
Okay, so Mr. Degerman goes in. If you'd like to place the factual, I will, Mr. Bowman, I'm gonna change your plea if you give me consent to a no contest plea. And what that means is that Mr. Dagermark goes in, will put the factual basis on the record using the elements of count 1 or count 2, understanding your plea is to an added count 3 of attempted felonious assault. So he's gonna put the factual basis on the record for the purposes of the plea from the other counts, okay? And I guess Mr. Degermer goes in, it would be for lack of memory, or civil liability. All right, so go ahead, Mr. Degermer goes in.
Your Honor, I would submit that, and I'll just bring up the police report. Your Honor, I would submit that the police report 46 APD 24003192, that based on that investigation at trial, the people would prove that there was sexual conduct between Manuel Bowman and the individual with the initials SR when that individual was between 13 and 16, that of sexual touching on the SR's private area, and I think that would satisfy the elements for no contest here.
So when you say private area, you mean the vaginal area?
Vaginal, correct.
Okay, Mr. Sneed, for purposes of a no contest plea, are you satisfied that he pled to the elements?
Yes, thank
of the
you.
greater for the purposes of the plea? All right. So based on the information placed on the record from the police report, the court finds beyond a reasonable doubt that during the time period of February 13 through April 3rd of 2024 in the city of Adrian and the county of Lenawee, that the defendant did touch with his hands the vaginal area of the victim in this case, who is between the ages of 13 but not quite 16, and therefore did commit the offense of attempted felonious assault, and the court will accept the no contest plea. Mr. Sneed, has the court complied with MCR 6.302 B, C, and D?
Yes, thank you.
Mr. Degermer goes in.
Yes, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. While the court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them, there has been a Killebrew agreement to no upfront jail and no upfront jail and no further charges. I'm going to refer this matter to the probation department for a pre-sentence investigation. Mr. Bowman, I'm going to set sentencing for March 21 of 2025 at 8:15 in the morning. Are you available that day, Mr. Degermer goes in?
Yes, Your Honor. Yes, Your Honor. Thank you.
Okay, and so March 21 at 8:15 in the morning. So, Mr. Bowman, I'm going to put you in a breakout room with Mr. Moore here in a minute, and he's going to give you some instructions about how to contact him and when you need to come in and talk to the probation department. You did enter a no contest plea. That means you do not have to make a statement about the events that occurred. Do you understand that?
Yes.
All right. Now, Mr. Bowman, as to the rest of it, be truthful with them about your background. They'll prepare a pre-sentence report. We will provide Say what? Oh, Mr. Bowman, for the record, we changed your attorney requested to change your plea to a no contest and not a guilty plea. Do you agree to have your plea changed to a no contest?
Yes.
To pick it up? Okay. All right. So sentencing, as I said, will be March 21 at 8:15 in the morning. Mr. Bowman, do you wish to appear in person or via Zoom?
Zoom.
All right, so we will have that via Zoom. All right, so I'll get a copy of the pre-sentence report to Mr. Degger Margosian. He's always good about it. He'll review it with you before sentencing. All right, Mr. Moore, I am going to put you in a breakout room with Mr. Bowman. Where'd it go? Okay, so Mr. Moore, Mr. Bowman. All right. You're all set, Mr. Bowman.
Okay.
Okay, so everybody hang tight. Okay, so don't go anywhere, Mr. Sneed. Mr. Dagermark goes, Zan, I think we're all set.
I'm all set. Thank you, Honor.
Okay, I'm